Patrick Tomlinson. Welcome to another episode of Reflections. Today we have with us Wilfred Holness, J.D., Ph.D., MBA. Professor Holness has consented to taking time out of his schedule to come to talk to us about some very interesting topics that I'm sure you'll find informative and enlightening. Professor Holness, welcome.
It's a pleasure to be here. Thank you so much.
Okay. You were born in Jamaica.
Yes, sir, indeed.
Yes. Tell me a little bit about that.
I was a little boy in Jamaica. That's when I was born on Portland Road.
Okay.
Off of, that's Kingston 16,
Okay.
near Rollington Town.
Okay.
Proper Rollington Town. And I went to a school not far from St. Joseph Hospital called Mavisville. As a little boy. I left there, came to the United States, started junior high school, which was interesting, getting used to the system. From there, I went to Aviation High School.
That's in Brooklyn or Queens?
Aviation in Queens. I should tell you first, my junior high was in Brooklyn. We were in Brooklyn. Many Jamaicans in Brooklyn. Even some of my friends from school, I found them in Brooklyn. Enjoyed airplanes, enjoyed the science behind them. From there, after I graduated, I didn't go to college. I was just pretty much running about. And I was driving a taxi, and someone had told me to get my act together. So I decided to go to college. And since I was in Brooklyn, and there was a school college there, Meg Revitz College, CUNY school. And I walked in there and I kind of liked it. It was like a
very popular college, and
it's a fantastic college. And I remember Omar was burning incense. He's one of the guys that was selling incense burnings. And I went and I remember Professor Johnson who had dreadlocks, and I said, "This is the school I'm going to try to take." Plus, they wanted me to come down to for basketball. I was a big basketball player. And I came down and I played basketball. I was all conference. I was MVP, a scholar athlete. And I was a member of the science department. Science department was all West Indians.
Okay.
Very competitive. Some great students. And I was able to get a scholarship in science. I was a Mark scholar. I was doing research on ubiquinones. Ubiquinones.
What is that?
It's actually a molecule like the quinones, which can get reduced and oxidized. And that's many years ago. I can't remember this stuff off the top. And it was used to detect glucose concentrations. Because I think there's a flip-flop that goes on 65-35 between an alpha and a beta glucose molecule. From there, I was recruited by a lot of graduate schools. I was National Dean's List. I was captain of the basketball team, captain of the debate team. I did really well. It was a really fantastic experience. That's why I always recommend for students to go to college rather than online. Well, I was recruited by Purdue University, Illinois, a few other schools in the Midwest, but I wanted to stay in New York. And I got recruited by Mount Sinai School of Medicine. And they were offering me a full ride and for the doctoral program. And they were doing some pretty interesting research. I ended up in a lab where I was doing research on heterotrimeric G protein signaling. This was a signaling from heterotrimeric G proteins, alpha subunits, which cascaded through to MET kinase, which is MAP kinase, and there was an inhibitory effect. At that time, a lot of research was being done on inhibiting cell growth because
why? For what purpose?
Because cancer.
Okay, so it was focused towards cancer. Your research, or
well, I'll explain that.
Yes.
To you.
Okay.
So microtubule or mitogen, then they changed it to mitogen associated protein kinases. Inhibition of that was a big thing because they were thinking that if you inhibited that, well, then you'd inhibit mitogenic growth of cells. But my research, it finally ended up being where I would work with an associated adenovirus. Now, these viruses are used in flus and all of that stuff, and we modified them and took out the early genes so they couldn't really replicate, and installed our constitutively active G-alpha S mutant, which would signal through protein kinase A, do catalytic, have a catalytic function, and cause a phosphorylation MEK kinase, which is MAP kinase, which would inhibit flow of signal through the MAP kinase pathway. It's kind of outlandish, but it was a lot of fun.
Okay.
And that was my doctorate on that.
Okay,
And
so you did a PhD in
Right. On
biology.
Right, but I should finish up on this. My work was on carotid arteries.
Mm-hmm.
And what happens is we're trying to inhibit the growth of a neointima, which is this, after you have a balloon angioplasty, there is a shrinking of the artery, and that's caused by a buildup of plaque formation. So the whole idea was if these G-alpha S in the virus would infect newly migrated cells, vascular smooth muscle cells, that the artery wouldn't get occluded and wouldn't get small because you're inhibiting the movement of these cells. So that's what that was on. And plus, I did work on hybridomas and things like that.
Okay.
During the time I was in doing my Ph.D., well, some brilliant thing came. I said, man, I really don't know anything about this world. So I decided to go to law school at night. So from Mount Sinai, I would catch a cab after a certain hour and get to law school on Fordham Law School.
Mm-hmm. Where was this? In the Bronx at the time?
Fordham Law School's on 62nd.
Okay, right.
And 9th or 10th.
Right.
9th Avenue.
Mm-hmm.
And found it very interesting. But again, I got more into the theory, like what we were speaking about earlier, suggesting the theory of law, which is this basis of the foundation, sets the basis of all things in the society.
Mm-hmm.
And fascinated with contract law. Torts were interesting, but property was more interesting because some of it was not straightforward. And so somebody said take up patents. Now in the night law school, what's interesting is we had about 11 PhDs that were all going into the biotech law, which was what I was doing, biotech patent law. And it was amazing.
So you're a biotech patent lawyer?
I'm a patent lawyer, but biotech is my specialty.
Concentration,
My
okay.
concentration.
Okay.
And so we had that. It was interesting. And a lot of the younger students that just came in from undergrad switched up and got away from us because we'd have some ridiculous discussions that had probably more to do with science than to do with law.
Okay.
So that was interesting. So from there on, I had sat for the bar exam.
Mm-hmm.
I'm a New York State licensed attorney.
Mm-hmm.
Next, in order to become a patent attorney, you have to qualify. You have to have a science background. You have to have a science degree or pretty much comparable in certain fields, which is going to be hard science. But that might not do you any good because you're dealing with PhDs and research scientists out there that come up with these wonderful, marvelous inventions. And you have to be able to understand what it is. Like the G-alpha S constitutive mutant I was talking about, you have to understand what that is, how to put that in writing so that you can get a viable patent. So I studied for the patent bar, which is like a 33% pass rate. After that, I had a PhD, so then I was in demand, and took a job in a firm. Actually, one of my colleagues from night law school, who I sat beside, who was a partner, I'm not going to mention the name. She, once I saw her name, she was trying to recruit. I came to say hello to her. She said, "Hi, well, I got a job for you." So I started in patent law that way. It was very interesting. I learned a lot.
Okay. And now you're in private practice?
I'm in private practice.
Okay. Very good. Very good.
If you think you may have an invention worth patenting, then filing for a patent would be your next logical step forward on the road to joining the pantheon of patent holders. The United States Patent and Trademark Office is the right place to start if you're thinking about filing a patent application but aren't sure how to do it. The USPTO is your one-stop shop. You can find the answer to all your particular patent questions right here. Let me walk you through an overview of the patent application process so you can begin to get your ducks in a row. You know what I mean. You can prepare for what comes next each step of the way. Before you go too far, understand that you can't just patent any idea. You have to have an invention for a process, a machine, something that can be manufactured, or even a composition of matter, or an improvement to an existing invention. Your invention should have a purpose or solve a problem. Maybe it is smaller, faster, less expensive, quieter, or environmentally friendlier than anything else like it. Of course, an invention can't defy nature. Everyone knows that. If you want to make a prototype, that's one way you can show the invention is useful and really works, but it's not required. Consider making a business plan before you even think about filing. Ask yourself who will buy your invention, what their buying habits are, and how much they will pay for it. Many resources are available to help you study the market. Start with the internet and public libraries. You can read magazines and journals and even do a search of already published applications and patents. Check out businessusa.gov for additional resources. The searching that you did to prepare your business plan can also help you with a patent search. For more assistance, you can also visit USPTO headquarters, your nearest USPTO satellite office, or the closest Patent and Trademark Resource Center. And hey, you can visit us online too. Because before you file a patent application, you should make sure somebody else didn't think of it first. Did you really invent something new? No need to reinvent the wheel. You did invent something new or improved? Well, look at you go.
If it really is novel and not obvious, then you may be ready to file a patent application so that your intellectual property is protected.
If you file a patent application all by yourself, the USPTO recognizes you as a pro se inventor. There are resources like this video designed to help you. You can go it alone, but keep in mind the process requires persistence and determination. Consider the help of a registered patent agent or attorney to assist you. The application process is likely to go more smoothly and with fewer mistakes if you seek representation. I'm just saying. You've made it this far in understanding the patent process, and there are still a few more important things to consider. It's not one size fits all for a patent. In fact, there are 3 types of patent applications: utility, plant, and design. So now that we've navigated through this challenging innovation journey, you might feel like an expert, or not so much. And if you're not feeling it, you can call the Inventors Assistance Center at 1-800-PTO-9199, or check the electronic filing system page at the USPTO website, and you'll find descriptions and examples for each section, along with contact info and pertinent patent particulars. So patent on, my fellow inventors, patent on.
So I wanted to get a little bit more, I would say, local, that we can speak to a lot of emerging and small businesses.
Okay.
So I'd like you to describe for us or define for us what is intellectual property.
Okay. How do you get from patents to intellectual property? Trademark to intellectual. Well, it's intellectual.
Mm-hmm.
And it's property. It's intellectual and it's property. There are basically 4 types of intellectual property. You have patents, you have trademarks, you have trade secrets, and you have copyright. The real interest in these things is based on commerce. Although copyright is not necessarily a purely commerce field of law.
Mm-hmm.
Now let's start off with what patents are. Patents is a right to exclude others, sale, make money off of an invention. Now, it has to be an invention, and it has to pass these statutory parameters.
Mhm.
Exactly. But they grant it for you for 20 years after you file your application. But sometimes, because you're going back and forth with the United States Patent and Trademark Office, which else, you will take longer. I mean, it'll take you a while to get your patents because you're going back and forth. Trademarks is a mark or an identification on a brand, on a particular product or service, and they call it a brand. So you'll know as a consumer what this product is. And I'm going to try to explain that. Trade secret is where you hide what you've done. And you don't put it out there in the public. And because you are protecting it, the law sees fit for you to keep it protected. So if you're doing your job and protecting it, if somebody steals it, the law will come in on your side. So that's a trade secret. Now you're talking about Kentucky Fried Chicken. Kentucky, those 12 herbs and spices by the Colonel is protected as a trade secret, famous trade secret. Another famous trade secret is the contents for the syrup for Coca-Cola. These are trade secrets. Trade secrets are sometimes worth it. Now and for the common person, it's not really worth it. When you're dealing with this large corporations like this, it's better for them to keep it to themselves. Because if they're successful in keeping it, well, this is something they keep forever. They'll never have to reveal it to you. Whereas with a patent, if you have a patent, you have to reveal it and give it back to the public, or what they call put it into the public domain
After
the
20
time
years?
after 20 years.
Okay.
Now, what I was telling you about the 20 years is that it could be longer in the sense that because the PTO has delayed or made some errors and made you delay getting your patents, which generally is in 3 years. So if you got it 3 years after, you really have 17 years. But it may take, like I had a patent that took 12 years of going back and forth. So they gave me a substantial amount of time extension to make up for the fact that they ate up so much time. You have to be very careful, and this is the thing, this is why you need an attorney. Because you have to be very careful about what you call your product. People sometimes call things their product, and it's very obvious. It's actually a description of the product that they're selling, or a description of the service they're ordering. That doesn't make it down to the United States Patent and Trademark Office. You're just giving them money. And by the way, the United States Patent and Trademark Office are the ones that are going to issue you registration for your trademark and issue you letters patents for your patent for your invention.
Okay, where's that? Can you just describe a little bit of the structure of the U.S. PTO?
Okay, the PTO, it's good to understand it through the process. You file an application, and we can touch on that in a little bit. You file an application with the United States Patent and Trademark Office. They will assign you an examiner who will look at your application. 99 to 100% of the time, they're going to find something wrong with your application. And they're not going to give you your money back. But what will go on in the case of a patent, you'll further this arguing. It's just like a court case. And they're going to give reasons why you don't deserve a patent, and you're going to try to say, well, no, this is the reason why I should get one, or maybe I could do something and get this patent. From there, you go to, and the examiner is called an examiner, and they issue something known as an office action. And this, by the way, is something that you'll find in almost all administrative courts. You'll have an office action. Office action is them rejecting you for whatever it is. It happens in environmental law, and I should have told you. I also teach environmental law as an adjunct sometimes. So it's kind of easier for me to teach environmental law because I work with the federal government, so I have an understanding of how they operate. So if you and the examiner can't see eye to eye, the next step is the PTAB, which is the Patent Trademark Appeals Board. And I think they generally side with the examiner. But you'd write an appeal to them, and they would they would make
Hearing.
They'd set up a hearing, or they would make a judgment on it on the papers.
Mhm.
After that, if they give you an unfavorable ruling, you have to go to the next court up, which
Okay.
is the Court of Appeals for the Civil Circuit, or for the CAFC, the Court of Appeals for the Federal Circuit. From the Federal Circuit, if you're not happy with that ruling and you want to go higher, the next step is the Supreme Court. So you actually travel up to the Supreme Court a lot faster. But then you have cert. That's the court's decision on whether it wants to hear your case or not. And if you're a little guy, let's be for real, you're a little guy coming in there with your little patent and you want to take up the time of the Supreme Court, you got an uphill battle, because they'd have to want to hear what you have to say.
Okay. Now, Professor, I just wanted to kind of ask you to home in on patents and trademarks and intellectual property as they relate to small business. Okay, so I'm a guy, I'm, mixing up my juices or, baking my baked products. Does a patent or trademark apply to me? Or I'm a guy going to the studio, as many of us in our community do, and sing a song. Is this applicable to us?
That is a great question. In my opinion, everybody, especially in this day and age, should look into getting a trademark first thing
On what?
for their business. And I'll let you know.
Okay.
Also, you want to look at patents. You want to get a competent, make sure you get a licensed United States Patent and Trademark Attorney. Ask them specifically, do you have a license to practice before the United States Patent and Trademark Office? And there's a reason for that, and because there are many scam artists out there that are taking people's money and cannot present themselves in front of the court. So you want to make sure you have that. Now, what does a patent, what does a trademark, what does trade secret do, especially patents and trademarks? Well, on the balance sheet, and those of you that understand business, to understand the health of a business, you're going to look at the assets, liabilities, and owner's equity. And you're getting right to the point.
Yeah, intangible assets.
Intangible assets, once you look at them, so now let's focus on the assets. Assets is the value of this company. Now what you put in your pocket is minus the liabilities, and that ends up in your pocket. But if you increase the assets and the liabilities stay the same, you're going to put a lot more money in your pocket. So the first part of the assets, your current assets, which is going to be cash. This is, I think, Warren Buffett's favorite part of the balance sheet. He wants to see somebody cash heavy, and that's where you have a lot of mergers and acquisitions. After you go through the cash assets, you move on to fixed assets, and from there, the bottom of this, it's an asset. It builds the value of the business. Is your intangible assets, just as you were saying there, Mr. Thomas. That building of the intangible assets increases the amount of assets you have. So the wonderful part about intellectual property is valuing intellectual property. What is the value of it? It's intangible. Remember we spoke earlier, you said it's a property, but it's intangible. You can't touch it. Now, one of the things I tell my clients, I give them an example. I said, well, not to say anything bad about Hunts Point, but let's say I take $1 million and I build a house, mansion down in Hunts Point with a swimming pool and a tennis court and 5 or 6 bedrooms. What is the value of it? Well, it's that same value. Now, what if I take that same house, same situation, and move it into Beverly Hills? Now the value of the house is 10, 20 times more. That's what intellectual property does. It boosts your value without you doing anything, any real work or anything. It's just because of the perception of the value of your intangible asset.
Okay, Professor Holness, remarkable points. I just wanted to share this with you. I was reading on the US PTO's website that, and this speaks to a lot of our community to be sensitized to this fact, is that you can also take a patent or use a patent as collateral at a bank.
Okay, that's where we're really getting to. So why is intellectual property, especially a patent and a trademark, so wonderful to have around? Let's take a look at McDonald's. That's my favorite company to look at. You're on the highway, you're driving down the highway, it's dark, and you're hungry, and you see on a billboard lit up a big yellow M. What are you gonna do? And it says next exit.
Stop and eat.
You're getting off, what are you gonna eat? You're gonna eat McDonald's without anybody putting the name McDonald's up there.
Mm-hmm.
What is the value of that golden M? What is the value?
Golden arches.
What is the value of it?
Mm-hmm.
Could you imagine that? I have Papa Joe's hamburgers. I come in there and I get maybe about 50 to 100 people a day, but I change it now and I put a big golden M out there. How much would that increase my business? At the end of the week, how much more will I have increased? A substantial amount. So once you build up equity, it's called like building equity in these brands, in these marks, you're good as gold. Because I would spend, I'm sure McDonald's doesn't have any assets. I'm sure the only asset it has is that golden arch.
Apart from the equipment, the food equipment.
Oh, I doubt they do.
Oh, you mean those are owned by the franchise?
Or they lease them out.
Right, okay.
McDonald's has no reason to buy anything.
Okay.
Even the trucks, lease the trucks.
Mm-hmm.
The only thing it owns is the golden arch.
Okay. Okay.
So that's the power, that's how
The power of intellectual property.
powerful, exactly, in trademark, and how you can increase your value,
Mm-hmm.
increase the value of your business. Just by that. I had a client and she came up with us, very interesting, I'm not going to really discuss it, but she came with a very interesting mark. And we had to struggle to get that. I had to tell her, the big guys can stop this mark. But they let it go. When I gave her the mark, I said, look, you're on the
We're talking the trademark?
Yeah, the trademark.
Mm-hmm.
I said, because they send you a certificate if you make it. So you're on the principal register. I said, this thing here, right now, is worth about $70,000, $80,000.
Mm.
And you only put up $3,000.
Mm-hmm. Okay.
So, yeah.
Excellent. Well, Professor Holness, we are coming up to the end of the first segment. I hope you can stay back, and I would like to drill down into 3 specific industries: hair products and skin and body products. I'd like to look at music and baking products if we can in the next segment, if you consent to that.
Sure.
So once again, I want to thank you, Professor Holness, for taking time out to discuss with us very, very interesting issues. Thank you for coming.
It's a pleasure.